Imagine Elena, a fictional Michigan voter, reading a headline about the Justice Department asking for the state's voter file. Her first question is not partisan. It is personal. What exactly is in that file? Who can lawfully request it? And does this ruling mean her vote or registration is suddenly in danger? The short answer is narrower and more important than the headline. On August 17th, Michigan's Attorney General announced that the Sixth Circuit had denied the Justice Department's request for rehearing by the full court. The court had already affirmed dismissal of the case. The fight involved an unredacted electronic statewide voter list, and Michigan was not ordered to hand that file over. That is a specific litigation result, not a national rule about every election record. The file at the center of the dispute is Michigan's Qualified Voter File, or QVF. The Sixth Circuit opinion says the requested list included names and other registration information along with dates of birth, driver license or state identification numbers, and partial social security numbers. Michigan supplied a public version with personal identifying information redacted. No real voter record appears in this video. To see how the case reached that point, go back to 2025. The Justice Department sent Michigan a series of letters, beginning July 21st, followed by letters on August 8th and August 14th. The letters sought the unredacted file and connected the request to federal election laws, including the National Voter Registration Act and the Help America Vote Act. Michigan did not send the unredacted electronic list. It provided the public version instead. The federal government then sued in September 2025, asking a federal court to compel production. The dispute was not about whether Michigan had a voter list. It was about whether this particular federal demand reached this particular electronic file under the law the government cited. In February, the Western District of Michigan dismissed the case. The Justice Department appealed, but the appeal focused on Title III of the Civil Rights Act of 1960. In other words, the question was not a general referendum on election administration. It was a statutory question about records, custody, and a written demand from the Attorney General. On June 24th, a Sixth Circuit panel affirmed the dismissal. The majority's first reasoning turned on a phrase in Title III, records that come into an election official's possession. The judges treated Michigan's electronic voter file as a list the state created and maintained, rather than a record that came into the Secretary of State's possession from somewhere else. That distinction may sound technical, but it changes the practical result. The ruling did not say the government had proved that every Michigan voter record was secret. It said the statute did not give this demand the right to obtain the internally generated statewide list in the form requested. The majority also examined the demand's wording. Title III says a written demand must state its basis and its purpose. The opinion describes the July and August letters as separating those pieces. One letter discussed alleged data anomalies without stating the purpose in the required way, while the later letter stated a purpose without repeating the basis. The majority concluded that neither demand, standing alone, satisfied both requirements. The Justice Department takes a different view. Its appellate page says the department is entitled to Michigan's statewide voter registration list under the Civil Rights Act and says the privacy arguments against access do not prevail. The department describes its purpose as investigating compliance with federal list maintenance requirements. That is the department's legal position, not the Sixth Circuit's holding. Michigan's position runs in the other direction. The state treated the public, redacted list as the version available for general access and resisted turning a sensitive electronic file into a bulk federal handoff. The court record describes the state's concerns, but the panel did not decide that every federal request for every voter record is invalid. It decided this case under this statute and this demand. Here is the distinction that gets lost in a headline. A public voter list, an internally maintained electronic file, and the individual applications or records used to build that file are not automatically the same legal object. My reading is that the case is really about the path from one layer to the next, what record was requested, how it was created, and what the written demand actually said. That framing leaves room for two legitimate concerns at once. Election officials need workable ways to check list maintenance. Voters also have a serious interest in limiting the spread of identifiers that can be used for impersonation or cross-database matching. The ruling resolves a statutory question. It does not establish a partisan motive for either side. The next step in the Sixth Circuit was not a new trial. On August 14th, the court denied rehearing en banc. The order says fewer than a majority of active judges voted to rehear the case, while one judge said he would have granted rehearing for the reasons in the dissent. That tells us the legal disagreement remains real, even though the panel decision stands. The dissent and a concurrence also explain why the story is not over in the broad sense. The order's discussion says the government might try a new, more specific request for underlying individual records rather than the aggregate list itself. That is a judge's view about what the opinion leaves open, not an order telling the Justice Department to make that request. At this production check, the Sixth Circuit rehearing order is the latest official court action located for this case. The Justice Department's public appellate page still presents its position and links the June decision. No Supreme Court filing was located in the official sources reviewed for this run, but that absence is not a promise about what a future filing or a different lawsuit may do. So, what changes for an ordinary Michigan voter? Nothing in this case cancels a registration, changes eligibility, or asks a voter to re-register. The lawsuit concerned a government-to-government demand for a file, not a notice requiring Elena or any other voter to submit personal documents. If you check your registration, use the official state election site or your local clerk. The privacy lesson is just as concrete. Do not send a social security number, driver license number, or identity document to an unsolicited requester because a headline made a government data dispute sound urgent. Verify the requester through an independently found official channel. That is general safety guidance, not a claim that this case involved a consumer scam. Elena's opening question now has a precise answer. The specific demand for Michigan's unredacted electronic statewide voter file did not succeed in the Sixth Circuit, and the en banc rehearing request was denied. But the ruling is not a finding that every voter record is private from every federal investigation, and it is not evidence of a data breach. The better headline is this: Michigan kept this voter file private for now, while the legal fight continues over what kind of record the government can demand, what authority it must name, and how precisely it must explain the request. If the next filing changes that picture, read the order itself. For voters today, protect your personal information, rely on official election sources, and do not mistake a narrow court holding for a nationwide rule.